Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On April 16th, 2025, the Honorable Stephen J. Hippler, District Court Judge in the matter styled as Idaho versus Kohberger, entered two orders granting the defense's two motions to seal discovery, both of which were dated April 15th, 2025. So we see here the orders are coming one day later. We addressed the motions in our last episode of the Indie Zone podcast, episode 574. If you have not yet had an opportunity to listen to that episode of our continuing series on the Idaho versus Kohberger case, I recommend that you do, because it'll provide further insight on what the defense was asking for. Let's look at these two orders. One is order sealing defendant's response to state's Exhibit S and Sam 1 to state's first supplemental request for discovery. And it says here, the court having before it the motion to seal defendant's responses to state's Exhibit S and Sam 1, to state's first supplemental request for discovery, and good cause appearing, now therefore it is hereby ordered defendant's responses to state's Exhibit S and Sam 1 attached to their first supplemental request for discovery shall be filed under seal pursuant to ICAR 32I and IC statute section 74124(1)B and C. So ordered April 15th. This is signed by Judge Hippler, but it is filed by the clerk on the 16th of April. Interestingly, the court here cites the statute and the rule. In the second order we're going to get to in just a minute, only one is cited. What is IC 74124(1)B and C? Well, first, that is a statute of the state of Idaho, and it is entitled 74, Transparent and Ethical Government. And it says here, exemptions from disclosure, confidentiality. Notwithstanding any statute or rule of court to the contrary, nothing in this chapter, nor Chapter 10, Title 59, Idaho Code, shall be construed to require disclosure of investigatory records compiled for law enforcement purposes by a law enforcement agency, but such exemption from disclosure applies only to the extent that the production of such records would. And then it goes through A through G. What is cited here is IC 74124(1)B and C. Let's see what B and C say. Subsection B says, deprive a person of a right to a fair trial or impartial adjudication. That is a due process guarantee to Mr. Kohberger. The next section, Section C, constitute an unwarranted invasion of personal privacy. And what this may have to do is with Mr. Kohberger's turning over of some medical records that the state had requested. The second reason given here, ICAR 32I, that's a rule of court, and it provides the trial court's authority to redact or seal court records that would otherwise be subject to public disclosure when a party's right, for example, is impacted. Let's go to the second order because it's a little bit different here in terms of the authority that Judge Hippler is citing. This is order sealing Exhibit E as in Edward to defendant's fifth supplemental request to discovery. And it says here, the court having before it motion to seal Exhibit E to defendant's fifth supplemental response to discovery and good cause appearing, now therefore it is hereby ordered that defendant's Exhibit E to their fifth supplemental response to discovery shall be filed under seal pursuant to ICAR 32. So the statute is not cited here, and neither is any specific portion of the rule cited. And there are multiple portions of ICAR 32 that gives the court the teeth or the authority to seal from public view certain documents that would otherwise be subject to disclosure. This will now conclude this episode of the Indie Zone podcast. My name's Kathy. Thanks for joining us here today.